Based on details at the scene, we believe this was an isolated, targeted attack on our victims.
He's very quiet, calculated about what he says.
I don't want to see an innocent man, but I feel like he's just scared to look at me in the eyes.
If you plead guilty or are found guilty, it is up to death and or imprisonment for life. Do you understand?
Yes.
The man accused of killing 4 University of Idaho students will be back in court next week for a motion to compel discovery hearing. Now, Bryan Kohberger's defense is asking the state to turn over evidence. Now, in response, the state listed all the discovery provided to the defendant, including 10,000 pages of reports, more than 10,000 photos, and approximately 9,200 tips. Now, in the filing, the defense claims certain reports may contain exculpatory information, but the state says in the motion response that the defense has not said what that information is, and if they know about it, the prosecution doesn't know about it, so let us know what it is. Kohberger faces 4 counts of first-degree murder and 1 count of burglary in the November 2022 stabbing deaths. Steve Gonsalves, the father of victim Kaylee Gonsalves, told ABC News, quote, "I can't wait to see the evidence, and then I'm going to bring it. And he's going to realize that this is the family that's going to make sure he doesn't get away with it." Several key pieces of evidence in this case surround Kohberger's actions after the murders. Court TV legal correspondent Julia Janae reports.
Handcuffed and dressed in a red jail uniform, Bryan Kohberger, the PhD student, made his first appearance as a defendant in a Pennsylvania courtroom. He was arrested at home with his parents on December 30th, wanted for the murders of Madison, Kaylee, Zaina, and Ethan, 4 college students in Moscow, Idaho.
I did not imagine the investigation would lead to the Commonwealth of Pennsylvania.
Pennsylvania State Police were asked for their help in his capture after Kohberger was identified as a suspect.
Mr. Kohberger was taken into custody without incident.
This news of his arrest came as a shock to the small community near the Poconos.
This place is known to be like a nice place, like it's a tourist place. It's the Mount Poconos. I mean, to hear this, it's so real for me. To be honest with you, it feels like a dream at this point.
Not only is the area better known for its scenic mountain getaways, it's more than 2,500 miles from the crime scene. Bryan Kohberger waived his right to an extradition hearing inside of this courthouse in front of a judge and a packed courtroom that included his family. That waiver started the process for his transport back to Idaho to face those 4 counts of first-degree murder.
Having read those documents and the sealed affidavits of probable cause, I definitely believe that one of the main reasons the defendant chose to waive extradition and hurry his return back to Idaho was the need to know what was in those documents.
Those documents are expected to reveal some of the evidence against Kohberger, including details about a white Hyundai Elantra the police say was in the vicinity of the victim's apartment around the time of the murders. Kohberger was driving a similar car when he was pulled over by Indiana police on December 15th. He was with his father on their way from Washington State back to their home in Pennsylvania. Kohberger was a graduate student at Washington State University in Pullman, the campus just minutes away from the apartment where the victims were slain.
In law enforcement, we understand the best thing we can do for victims and their families is to follow every lead, collect every piece of evidence, and bring those responsible to justice.
All right, still with me, civil rights and appellate attorney Mark McNaught and former criminal defense attorney Kirk Nurmian. Mark, let me start with you. I mean, this whole part of this pretrial practice, big important part of these cases, a lot happens here. I can't help but feel like the defense here is attempting to control the narrative somewhat. This is the second time that they're claiming and exclaiming about possible exculpatory evidence. They did it with the surviving roommate, wanting to depose her and talk to her, so they're going to travel out there and talk to her. Now they're doing it here. That's my feeling. Your thoughts?
I think you're probably right. I mean, I think there's the 2 things going on. First, they do want all of the evidence that they can get, right? They want to know the entire state's file. They want to see what's in there. exculpatory, inculpatory, whatever. But I also think that they are making, they know that this isn't happening in a vacuum, that there's a lot of media coverage on this. And so they know that the more noise that they make about there's going to be exculpatory evidence, we don't know what all the evidence shows. I think that does set a narrative, especially in a case like this, where the only evidence is circumstantial, and it's not like there is a link between Mr. Kohberger and any of these alleged victims. And so given that you've got this circumstantial case, it makes a lot of sense to get out in front and say, look, there's a lot of evidence that we don't know about.
Kirk, and I understand what Mark is saying, but my point is they've got 10,000 pages already, 10,000 photos. They have 9,200 tips they need to go through, and those could be helpful. You never know what's going to be in there. There's no body cam footage, but apparently there's 51 terabytes of information that involves all kinds of different reports, that involves video evidence, all types of things. There's no way they've gone through all that to figure out the fact that there's nothing exculpatory and they want anything to be handed over. I think it's definitely something that they're doing purposefully.
Well, look, I'm going to push back a little bit, Mike, because remember, this is a potential death penalty case here, and there's no limits on the scope of information. The fact that X amount has been disclosed really means nothing if they feel like there's other things in the investigation that could be exculpatory or maybe perhaps mitigating when we talk about that mitigation phase in death penalty. So they're very, and keep in mind, too, when we talk about a death penalty case, the defense attorneys, they have a certain requirement of diligence and zeal in order for any conviction or any death sentence to hold up, and we could be doing it again. So they are right to go after every single bit of evidence that they possibly might think. And of course, they have another source of information, their client. What is their client telling them? What does he see? So there's every reason for the defense to move forward as aggressively as possible, not only in the court of public opinion, but ultimately in front of those 12 jurors that are going to decide the fate of their client.
Yeah, I have to agree with that. Can't argue with that. Well, a couple of interesting things we found out from the paperwork. There was, in fact, an interview of Kohberger by the lead detective, Detective Payne. There are lab reports of forensic evidence. And if you remember, there was a fingerprint found on the sheet. There was also some hair found in his apartment that was dog hair, which may match the dog that was found in the place where the murders happened. But here's what I found interesting, Mark. The state fought back. They're saying, look, we've turned over everything. We have an obligation to turn over exculpatory evidence. We haven't seen any. If you've seen any, let us know, because we're not aware of any.
You hear that. I have heard that a lot in my practice. When we're talking about discovery Brady material, the state's always saying, well, if you think it's exculpatory, tell us. Well, we, as the defense attorney, you're like, well, we don't know. We don't know what's in your file. Like, I can't tell you why your evidence is exculpatory, but you have an obligation to give me everything.
You know what's interesting, Kirk, and as I said earlier, please explain to our viewers. Well, let me ask you this. These numbers I'm throwing out, 10,000 pages of reports, 10,000 photos, 92,000 tips. How does an attorney sit down and get through all of that information? Because as you said, death penalty case, zealous representation, you got to work your way through this stuff.
Yeah, I mean, it just takes a dedication to your client and your situation. And boy, you do have to go through it. I mean, it is a long 12, 14-hour days. You've got a gluttony of information, electronic data. I've been there. That's why these death penalty cases take so long to get to trial. People are frustrated. But when you have that amount of evidence and the defense attorney has an obligation, they're putting in a lot of work, and they're having to review that and digest that as best they can, so they are providing effective assistance to counsel. Because, Michael, most death penalty cases, if they get overturned, it's going to be at that sentencing phase because the defense attorneys didn't present certain information. So it's not just a matter of the case. We talk about all that evidence, but it's also that mitigating information. That's why, typically you have two attorneys, you have investigators, things like that, because it takes a lot to get a death penalty case to trial and to provide your client with diligent representation.
Yeah, no doubt. It's a lot of work on both sides, Mark. So my question for you is, oftentimes when we see this type of motion practice, things going back and forth, once everybody gets a real sense of what's out there, what their case is or it isn't, negotiations kind of pick up. You think there's a possibility of a plea in this case?
I think that if you've got a case that is a potential death case, there's always going to be a universe where that can happen, right? If the alternatives are to be executed in custody versus some type of a life sentence, life with parole, life without parole, there's obviously always going to be a math on the part of the district attorney and on the part of defense counsel and the person who's charged with the crime over whether to consider, pleading to something lesser. So I think that's definitely on the table. It's always on the table, but it really is. I mean, as you're saying, you got to wait to see how everything shakes out. Wait to see how strong the case is on the state side. See how strong the defense's side is before really getting into that conversation.
Yeah, absolutely. A lot of posturing going on.